I see we have live feed to YouTube. My name is Henry Green, and I will be the presiding judge today. Let me introduce the other judges that are with me on this panel. We have G. Gordon Atchison, and we have Catherine Gardner. And the first case that we have this afternoon is 121649, Joseph W. Lambert and Sharon L. Lambert. They are the appellants versus the city of Leawood, Kansas, which is the appellee. Now, let me get the appearances of the attorneys. Appearing for the appellant.
John Duggan, Your Honor.
Thank you very much, Mr. Duggan. And appearing for the city of Leawood.
Your Honor, Michael Sack on behalf of the city of Leawood.
Thank you very much. Mr. Duggan, this case is set for 15 minutes. Do you want any rebuttal time?
Yes, please. I'd like 4 minutes for rebuttal.
And are you ready to proceed with your argument?
Yes, Your Honor.
Okay. Well, you know, we've read your briefs and we've had a memo prepared for this. And so you can just dig right in where you want.
Thank you.
You may begin.
Rights granted under a duly passed zoning ordinance, which now affects those specific properties, must follow state mandated due process requirements by notifying in writing those property owners whose rights are going to be affected and identifying a zoning ordinance if it's going to be repealed or modified. Here, the city claims that it effectively repealed zoning ordinance 789, which was duly adopted in 1983, and changed the setback rights and height limitations that were established in ordinance 789 without ever formally repealing or amending ordinance 789 or holding a public hearing after providing written notice to the 193 homeowners in Leawood Country Manor. What's important to note is under Kansas law, ordinance 789 repealed or modified by the governing body of the city of Leawood. The fact is the 2010 and 2017 ordinances that the city staff claims retroactively impacted ordinance 789. There's not one syllable of text in those two ordinances in 2010 or 2017 that suggests any retroactive application. In fact, to the contrary, they expressly state that existing property rights will be unaffected. There's nothing in either notice in 2010 or 2017 that suggests Leawood Country Manor, ordinance 789, duly adopted in 1983, or any existing rights are going to be impacted by the consideration or adoption of the 2010 or 2017 ordinances. The fact is that the 2010 and 2000 mention the zoning district that was approved in ordinance 789. The zoning district in ordinance 789, which is in the record, volume 3, page 165, the actual reference in that zoning ordinance is to R1 single family residential district, capitalized a defined term under the 1978 zoning code. The 2010 and 2017 amendments to Leawood zoning ordinances don't even mention that zoning district. They mention a different zoning district that came along later in time, an R1 planned single family low density residential district, 15,000 square feet per dwelling. The Lambert's property nor anybody else in Leawood Country Manor was ever zoned the zoning district that was purportedly amended by the 2010 or 2017. What the long and the short of what's going on here is this will create havoc in the public records because the title insurance for every property owner in Leawood Country Manor makes reference to the zoning ordinance because it's got a lengthy legal description in it that sets forth all the properties that were subject to zoning ordinance 789. And when you do title work, when people buy and sell houses, they get a title report that shows ordinance 789, which has never been repealed, modified, or in any way, shape, or form touched. They get their title work, they think they're operating under an R1 single family residential by express provision according to the 1978 code, which is a 35-foot tall building, 30-foot backyard, 35-foot front yard, and appropriate side yards. So show what the city considers the zoning to be. And when you zone property, I've zoned hundreds of properties in 32 years. I just got done rezoning some property in Olathe on Monday night from C2 to CC. What happens when you rezone property is that property in Olathe was zoned under a 1988 ordinance, and now it's been rezoned by a 2020 ordinance. The 2020 ordinance will say expressly it repeals the 1988 ordinance, and the new zoning is this zoning with these stipulations attached to it. And a new zoning ordinance under state law is published in the newspaper so everybody knows, and then it will be recorded of record so it shows up on the title of that piece of real estate. So whenever somebody buys and sells it, anybody trades it, real estate brokers investigate it, title insurance companies investigate it, they know what the current zoning is. The city of Leawood is suggesting in this case that none of those state law requirements, none of the public records, including exhibit or ordinance 789, needed to be changed in any manner, and that they could do this by simply making changes to the height and setback limitations in a 2010 amendment and a 2017 amendment that would somehow percolate back through the public record system with no identification for a title insurance company, no identification for the Lamberts, no identification for any other property owner, and that somehow all the title insurance companies, the buyers and the sellers and the real estate people would know that's what was supposed to have happened.
What is your,
Go ahead, I'm sorry, John.
yeah, what is your view of your client's rights at this point? Are they the rights under the old ordinance, 789?
Yes, and the reason I believe that, Judge, is I believe the city of Leawood in 2010 and 2017 made a general change to their zoning ordinance that was prospective. It didn't have any retroactive effect because there's no retroactive language, and it didn't go through the due process requirements to change 789. It didn't modify it, repeal it, or in any way impact it. So when we went to the district court, we just asked for the simple relief to have an order issued that said those new zoning ordinances don't apply to the Lambert's property, and the building permit application that they submitted for the home that completely complied with the requirements of 789 should be prosecuted and processed according to the current building codes and life safety codes.
And that would be true for everybody in the subdivision. I mean, it's not something you're asking uniquely to the, I mean, it's uniquely to the Lamberts.
You're breaking up a little bit, but I agree, it would be true.
But it applies to everybody.
That's correct.
Okay.
And I think it's important to understand in Kansas, there are two mutually exclusive groups of people that would get notice whenever there's changes to a zoning ordinance. One is a general application, which I think the city did here. And you don't give notice to individuals in that case, largely because it doesn't impact individuals who already have zoning ordinances like 789 in effect. It only impacts people that come in after the ordinance is put in place and they make a willing decision to trade their existing rights for new rights by rezoning their property. And of course, when they trade to rezone, they're going to be on full notice of what they're asking for because they're actually coming to the city to rezone their property. Those persons who are intended to be directly affected by the change in zoning. And if you're going to affect people's property, then of course they need to get notice because the state legislature has said, we deem real property rights in the state of Kansas important enough that if you're going to change those rights, you're going to modify Ordinance 789, you better tell them. The city has said, and I think this is kind of Mike's a friend of mine, but I think this argument is a bit obtuse and maybe a red herring. We didn't intend to affect your property specifically because we intended to affect all R1 properties. And I thought about what's the best way to explain it, and it is you can't have your cake and eat it too. You can't say, well, we never intended to affect the Lambert specifically, but once we got the ordinance approved, we then applied it specifically to the Lamberts. It just doesn't make sense. Groups of people. And if I saw a group of buddies or I was in a group of people, you might get hit by a water balloon. Well, to say, well, I didn't throw that water balloon at you, I threw it at a group of people. I didn't intend to affect you specifically. I intended to affect the group, even though everybody's getting wet when they get hit by the water balloon. In the same way, the city seems to be saying, well, we didn't really intend to affect the Lamberts. We just intended to affect everybody like the Lamberts. And I would say, in closing on my first leg of this argument, I don't think the city staff has got it right. I think the city staff is outside the bounds of what they have the authority to do. I think the ordinance doesn't apply retroactively. It doesn't impact Ordinance 789. It's never intended to change existing rights. It's a prospective ordinance that applies to future rezoning requests.
Elaborate on that for me a little bit. I mean,
Lamberts when they come through the front.
Who does that apply to then? I mean, the 2010 and the 2017 ordinance.
Anybody that comes in, Judge, and wants to rezone property after 2010, and there's agricultural property, there's RA5 property, which are big lots, maybe where somebody has a 10-acre plot and they have one house on it, they can come to the city after 2010 and they can say, I want to rezone to R1 planned single family low density residential 15,000 square feet. That zoning ordinance applies to them because it's prospective, and if you come in after it was adopted and rezone to that zoning classification, that zoning ordinance would apply to you. I think I've used up my initial 11 minutes, or I'm close to it, so if there's any other questions, I'm happy to answer.
Thank you very much, Mr. Duggan. Mr. Seck, are you ready with your argument?
Need to unmute there.
There we go. Sorry about
Yes.
that. From the city's perspective, this is really a matter of statutory interpretation. The argument in the petition is that we failed to provide written notice specifically to the Lamberts about the 2010 and 2017 ordinances. And 12-756 provides for publication, which we did. And the plaintiffs contend that 12-757B required specific mailing of notification to the Lamberts. But the statutory language doesn't support the plaintiff's position in their petition or their papers. It says written notice to property owners is required if it's not a general amendment to existing regulations and it affects a specific property. And here we have a general amendment to the existing regulations, and we have, and it does not affect a specific property. It affects all the properties that are zoned R1. And as to the specific ordinances that are at issue here, they have to do with when people want to remodel or rebuild. And so in this case, the Lambert's house burned down and they came into with plans to remodel or rebuild their residence. And at that time, they were informed that they could rebuild their house the way it was. So they had their property right from the day they bought their house to rebuild the same house. That was never denied of them. But what they wanted to do is what I described to the district judge is build a bigger and badder house, larger footprint and a higher one. That simply does not require, though, written notice to them. So we have publication, which is sufficient under the law. And now the issue becomes, is this claim barred by the statute of limitations? And the argument, I believe, in the plaintiff's papers are that they filed their petition within 30 days of the decision of the Board of Zoning Appeals to deny the variances that Mr. Lambert had requested. The problem is the denial of the variances are not the subject of the petition. The subject of the petition is the legality of the passage of the ordinances, which occurred in 2010 and 2017. Now,
Mr. Sec, doesn't the 30-day period by statute apply to challenging the reasonableness of the ordinances, which to me goes to the legislative policy and the decision-making of the body for that purpose, as opposed to a deficiency in how the ordinance was processed, which would go to the validity of the ordinance as a piece of legislation? I mean, it seems to me those are two different things. I'm not sure I've drawn the distinction very clearly, my question.
Judge, I do understand your question, but if you look at the St. John versus City of Salina case that we've cited, the court made clear that these challenges in St. John was a declaratory judgment, just like this. The challenge as to the legality of passage of the rezoning is also subject to the same statute. It has to be one and the same, because reasonableness is part and parcel of legality. If you have an illegal passage of an ordinance, then that ties in or dovetail into the reasonableness of the denial.
That's I would call it the old Court of Appeals case. It's like in volume 9 of our court.
It's back here. It's back here somewhere on the shelf.
Okay, but it's the Court of Appeals case from some time ago.
That's correct.
Okay.
That's correct. But the point of this is that the 30-day statute of limitations is not pigeonholed into simply determining the reasonableness of the action of the Board of Zoning Appeals, because here they don't even contest in the petition the reasonableness of the Board of Zoning Appeals. What they contest is the validity of the ordinance, and I believe the 30-day statute still applies. Now,
could you address Mr. Duggan's argument about 789 somehow not being repealed and still being in effect?
Well, I think the language in the two ordinances from 2010 and 2017 has the sufficient language to indicate that the ordinances previous to those two are being modified and repealed. In the body of 2475, it says modifications of required height and square footage restrictions in certain limited instance and repealing existing sections. And again, the limited instances we're talking about is when you remodel or rebuild. It's not a matter of somebody coming along, buying a lot and not being able to build what they want other than what was existing at the time that they bought the lot.
Is there a uniformity problem then in that someone building on a lot for the first time could build to 35 feet high and a different density than someone who is rebuilding like the Lamberts?
The argument is whether or not the ordinances under our statute are uniform in nature, and they all apply to R1. And so you have subsets within R1. You've got new construction with a 35-foot height, and then you have two different subsections that have to do with whether or not there's two-story houses on either side. There is uniformity. It's R1 with subsections to R1. And it just depends on the facts coming to the city in terms of what the application requires. A new construction gets 35 foot, but old construction, and the policy behind it, I think, is pretty clear if you've ever lived in and around Mission Hills, Leawood, and Overland Park.
I can't afford to live there. I'm a public servant. So explain I'm puzzled by the policy. I mean, I'm not sure it's an issue, but I find it odd.
The policy is really simple, Your Honor. I grew up in Prairie Village. I can't afford to live there, but all of the ranch style houses in Prairie Village are being knocked down and mega two-story houses are being built. And the issue is whether or not that blends with the rest of the neighborhood. And that has happened throughout the metropolitan area, and it doesn't blend with the neighborhood. And it causes some consternation on the part of the neighbors. But that's the policy behind this, is to try to maintain some uniformity while letting people improve what was existing at the time. So again, the Lamberts can rebuild their house the way it is right now. And that's fine. That's well within the statute. But back to your original question, there's not a uniformity problem here. It's all affects R1 zoning classification with subsets depending upon the circumstances of the individual making application for construction or remodeling. The other item that I don't want to ignore everything else that's in our papers, but in terms of the non-uniformity question, that was never raised in the petition. It was never raised in the plaintiff's motion for summary judgment. It first comes up in their response to our motion for summary judgment. So I'm not really sure that it should be considered by the court, but be that as it may, we've discussed that point. The remedy here is really for this court to affirm the lower court grant of summary judgment for the city. And I have no other comments unless the court has questions.
I do have one question. When the court talked about untimeliness and you argued that to the district court, were you relying solely on the 30-day rule, or were you also arguing a 5-year statute of limitations under 6511?
I did not raise the 5-year.
Okay.
It was strictly the 30-day. And again, it goes back to an attempt to skirt the 30 days by tying it to the decision of the Board of Zoning Appeals. But the petition says nothing about the Lambert's dissatisfaction with the vote by the BZA. It's the dissatisfaction with the passage of the ordinances. So I don't know that you can avoid the 30 days by saying, wait a minute, look at the BZA action. But it's just the 30 days. I never raised the 5-year.
Thank you.
You're welcome.
Have you completed your argument, Mr. Seck?
Yes, Your Honor. Thank you very much for your time. I appreciate it.
Thank you. Now we turn back to you, Mr. Duggan. You still have your full 4 minutes of rebuttal.
Thank you, Judge. Let me talk first about the statute of limitations and why the 30-day KSA 12760 doesn't have any application here. First of all, nobody, a title insurance company, a property owner, or anybody else could discern from the 2010 or 2017 ordinances that they have any retroactive application, that they repealed, modified, or amended Ordinance 789. Why would the Lamberts or anybody else in Leawood Country Manor, for that matter, ever go to the city and to sue them for a general change to the zoning ordinances that don't affect their property? And until they were told by the city staff that the city staff was now going to apply it to their property retroactively, that was the first time they ever had noticed that it did apply to their property. The St. John's case relied upon by Mike and the trial judge in going with the 30-day argument has nothing to do with this case. In St. John's v. City of Salina, those parties all received written notice. Those parties filed a protest petition. Those parties showed up at the public hearing and argued against the rezoning. They just didn't file their lawsuit within 30 days, and the court said you're out of time. In this case, our contention is the city staff's efforts to apply these ordinances to Leawood Country Manor, Lot 27, owned by the no property owner, no one would ever think it applied to them because there's no language that suggests that that's what's going to happen. So until they're notified by the city, we're going to apply this to your property. Why would they sue them? We also made the point in the brief that Crumbaker says, unless proper notice is given, the Planning Commission and the City Council have no jurisdiction to act on a zoning matter. And so there's no case in Kansas that says you have to file a jurisdictional challenge to a zoning application within 30 days. I think back to Judge Atchison's point, it is a reasonable standard. And our contention here is I sought declaratory relief to force the city staff to not illegally apply an ordinance to my property that no objective human being reading those ordinances could ever conclude ever did apply to my property, because there's not one syllable of language being changed or that it should be applied retroactively. As it relates to the uniformity questions, I agree. That's why we briefed the issue, and it was front and center, notice pled in our petition, in the summary judgment papers. Please check the record and the citations in our briefs. This is illegal on its face, even prospectively, in my view, because it treats different property owners differently in the same zoning district. To suggest that it's all R1, well, guess what? Leawood's got 5 different single family zoning districts: AG, RP, A5, R1, RP1, and RP2. They all have different massing and setback requirements. To say, well, it's uniform because it's single family residential is just not correct, because all those zoning districts, all 5 of them are single family residential, and each one remodel, rebuild, and we want to put Leawood Country Manor in that new zoning district, that would be a rezone that required notice. And that's effectively what the city staff is saying they want to do after the fact, even though there's no objective language. They didn't follow the state procedures to amend 789. They didn't do anything. They would like to create havoc and have you apparently assist them in doing so by writing an opinion that says the cities don't have to go back and follow the state mandated processes. They can effectively amend all their old zoning ordinances by amending a later general zoning ordinance and then claim that it somehow impacted all those prior ordinances that are still of public record, running with the land on all these properties that have never been changed. And I think that is why we don't buyers and sellers and everybody else is not worth requiring the city to do what any private citizen has to do. You want to rezone property, you got to send out mail written notice and have a hearing and let those people show up and have their opinions heard and then build on it. I don't think the statute applies retroactively.
I had a question, Mr. Dugan, about the notice, the statutory interpretation of 12757B, which distinguishes between notice by publication and notice in person, or mailed notice to a specific individual. How does that apply to your clients?
Well, I think two things, Judge. One, I don't think there was ever a revision to any zoning ordinance that changed my client's rights or anybody else in Leawood Country Manor. This was a general change that the city can affect prospectively by publication. But when the city staff says, for some unknown reason, concluded, yes, the intent of the governing body was to apply it retroactively, then that triggers my client's rights to get mailed written notice, because there's no doubt if it was the intent to apply it to Leawood Country Manor, it was intended to apply to their specific property rights as vested under 789, and the city intended to change it. And when that event happens under state law, my clients and everybody else who's affected is supposed to get written notice, and they're supposed to be told 789 is changing on you. You better show up and you better make your voice heard. I don't have anything further. I appreciate your time, and if there's any questions, I'm happy to answer them.
Are there any other questions of the court?
No.
We appreciate
Thank
your
you
argument,
so much.
Mr. Duggan, and we also appreciate your argument, Mr. Seck. We will take this case under advisement and get your written opinion as soon as we can. Thank you very much.
Thank you.